plaintiff Andrew Griffin alleges that both defendants conspired with third parties in order to defame her. The elements of the common law claim for civil conspiracy are: 1. A combination of two or more persons acting with a common purpose to do an unlawful act or to do a lawful act by unlawful means or for an unlawful purpose. 2. An overt act done in pursuance of the common purpose. And 3. Actual legal damage. In count ill, plaintiff Griffin alleges that defendant Granny's watching has been targeting Ms. Griffin since 2021, but that the attacks intensified in 2024. Ms. Griffin makes bold and bald allegations that defendants have acted in concert in a coordinated effort to attack Ms. Griffin, with no specificity as to the acts of either or both defendants. At best, Ms. Griffin avers in count, identifying various causes of action, including defamation, that defendant Granny's watching called Andrew Griffin a tragedy pimp and a grifter, with no reference to when these words were spoken. But calling Ms. Griffin names does not create a civil conspiracy. Ms. Griffin also alleges that unnamed persons influenced by defendant Granny's watching made false reports that led to Ms. Griffin being falsely accused and arrested, again without specificity or any attached proof of who these persons are or how these purported persons are connected to either of the defendants. Nor does the complaint identify the date of the purported arrest or the dismissal of any purported charges. Moreover, Ms. Griffin fails to plead, let alone establish, a prima facie claim for actual legal damages. Although Ms. Griffin makes a vague and general allegation that the conduct of defendants damaged her reputation in her profession and her professional standing, she does not identify any facts pertaining to any persons or businesses which have purportedly canceled or decreased any business with her as a result of defendants' actions. In light of the foregoing, the court concludes that the complaint fails to establish a prima facie case of a legally sufficient claim raised by Andrew Griffin against defendants for a civil conspiracy, and that claim must be dismissed. Defamation plaintiffs Andrew Griffin, Brittany Jackson, Tony Mathis, Christina O'Donnell, and Nick Hatsif-Stathia allege various counts of defamation against defendants. Based on the complaint's allegations, each of these plaintiffs is either a public figure or a limited-purpose public figure under Pennsylvania law. As public figures or limited-purpose public figures, these plaintiffs bear the heightened burden of establishing that the statements made by defendants were false. But plaintiffs have failed to establish this in their complaint. First, this court reiterates that the complaint is devoid of the clarity required by the rules, and, as a result, it is difficult to discern what, if any, statements at issue here can be attributed to either defendant, even if the court were able to ascertain the allegedly violative statements. Statements of opinions that cannot be established as provably false are protected by the First Amendment. Further, the complaint does not identify any person who heard these statements or describe how these purported statements have caused a loss of these plaintiffs' professional credibility. Again, such specificity is required in the Commonwealth under Rule 1019. Moreover, there is no allegation that would establish that any of these statements were false, and to the extent they were defendants saying subjective opinions, they are not actionable. Plaintiffs Andrew Griffin, Brittany Jackson, Seth Rogers, and Christina O'Donnell's purport to state claims of intentional infliction of emotional distress. A thorough reading of the complaint leads the court to conclude again that plaintiffs have failed to plead with clarity or specificity and cannot demonstrate that defendants' conduct was outrageous or extreme. Once again, this court notes that the alleged YouTube broadcasts/podcasts have not been quoted or specifically referenced, without the specific statements of defendants vis-a-vis the plaintiffs asserting an IIED claim. This court cannot determine that any statement was so atrocious or outside the bounds of civilized society to have caused a harm to plaintiffs. The few quotations of purported statements of defendants sung that are contained in the complaint, that Ms. Griffin is a tragedy pimp or a grifter, or that Ms. Jackson was worthless and lazy do not allow the court to conclude that there is a cognizable IED claim. Further, none of the plaintiffs has pled that actions or statements of defendants have caused them to seek a medical diagnosis or treatment. There are only the threadbare allegations that these plaintiffs suffered emotional pain and mental anguish. As such, plaintiffs have failed to establish a prima facie case to recover for IED in counts I, 7, 12, and XXVI, and these claims must be dismissed. Plaintiff Andrew Griffin's purported claim of interference with prospective business also fails for lack of any specific facts to establish this claim. Ms. Griffin's allegation pertaining to the purported claim for tortious interference with prospective business is as follows. Defendants' repeated defamatory remarks and encouragement of harassment against Ms. Griffin constitute such improper conduct preventing her from securing work and maintaining professional relationships. This complaint, like in one in the Foster case, fails to distinguish between the prospective or existing contractual relationships and fails to set forth any facts that would establish that Ms. Griffin was entering into any contracts with any business, let alone an interference with such contracts. Ms. Griffin fails to list any named entities with which she is contracted or with which she was prospectively going to be contracted. Moreover, this section of the complaint does not identify which of the defendants made statements that interfered with Ms. Griffin's prospective or current business relationships. Nor does this section set forth which statements were made vis-a-vis Ms. Griffin or when these alleged statements were made. Asterisk. As such, the purported claim of interference with a prospective business relationship is not supported by evidence and is therefore wholly deficient, as Plaintiff Griffin has failed to establish any facts in the complaint as to one or more essential elements of this claim. The defendants are immune from liability under Pennsylvania's Anti-Slapp statute, and this claim must be dismissed.